And Mr. President, to your indulgence for being part of this discussion, presiding in the chair, with special thanks to the distinguished Majority Leader who gave me the opportunity to open this discussion about FISA this morning. With that, Mr. President, I yield the floor.
The Senator from California.
Mr. President, I'd like to make the opening statement, at least as the committee chair on the bill that's before the Senate. This bill is a simple bill. This is a House bill that extends, it reauthorizes the Foreign Intelligence Surveillance Act called the FISA Amendment, Section 702. It reauthorizes it for 5 years, until December 31st, 2017. That is all it does. Without Senate action, these authorities to collect intelligence expire in 4 days. That's the reason it's the House bill before us. And that's the reason why I urge this body to vote no on all amendments. Send this reauthorization, well, it goes right to the President if we accept the House bill and get it signed. If it goes past the first, the program comes down. The program is interrupted. So this is important. It has the support of the Director of National Security, Jim Clapper, the Attorney General, Eric Holder, and other national security officials who have made clear as to the importance of this. And at this time, following my remarks, I'd like to enter letters into the record from all of the administration, essentially saying this is our highest intelligence authorization. Let me explain what the expiring provisions do. I assume that's agreeable with the President, that these letters go into the record following my remarks.
Without objection, the letters will be added at the conclusion of the Senator's remarks.
Thank you. Let me describe what these provisions do and why they're necessary to reauthorize. What will end on December 31st is Title VII of FISA. That's called the FAA, the FISA Amendments Act. This authorizes the executive branch of the government to go to the FISA court, which is a special court, and most people don't know this, of 11 federal district court judges appointed by the Supreme Court who review government requests for surveillance activities and obtain annual approval for a program to conduct surveillance on non-United States persons. In other words, surveillance on individuals who are not U.S. citizens or lawful permanent residents and who are located outside the United States. Under current law, the Attorney General and the Director of National Intelligence may submit an application to the FISA court. I call this a program warrant. It identifies the category of foreign persons against which the government seeks to conduct surveillance. This application is accompanied by targeting and minimization procedures that establish how the government will determine that someone targeted for surveillance is located outside the United States. And secondly, how it is going to minimize the acquisition and retention of any information concerning any United States person who accidentally gets caught up in this. If the FISA court finds the procedures to be consistent with both law and the Fourth Amendment, now remember, these are 11 federal judges appointed by the Chief Justice who sit on intelligence questions exclusively. If they find it to be consistent with law and the Fourth Amendment, they enter an order authorizing this kind of surveillance for 1 year. And they have found both, and they have authorized the program to continue. The process that follows allows the intelligence community to collect the communications of international terrorists and other non-U.S. persons who are located outside the country by acquiring electronic communications such as phone calls and emails sent to or from a phone number or an email address known to be used by the person under surveillance. Without this authority, the intelligence community would need to return to the process of going to the FISA court in every individual case involving collection directed at a non-U.S. person, and to prove in each case that there's probable cause to believe that the individual is part of or working for a foreign power or a terrorist group. Now, here's the question. Can the government use Section 702 to target a United States person? The answer to that is no. The law specifically prohibits the use of Section 02 to direct collection against, that means target, United States persons. So no one should think the targets are U.S. persons. This prohibition is codified in Section 702B, which states that surveillance authorities may not be used, and let me quote the law, to intentionally target any person known at the time of acquisition to be located in the United States, or to intentionally target a United States person reasonably believed to be located outside the United States. Now, if the government wants to engage in electronic surveillance targeting a United States person for foreign intelligence purposes, it must go back to the FISA court and it must get a specific order from that court. In an emergency, the surveillance can commence before the court order is issued, but the government still must have probable cause to believe that the United States person is an agent of a foreign power. Now, what does this mean? It means once the foreign person is targeted and the information is collected, if it goes to a United States phone number, that phone number cannot be used for surveillance without a warrant. That phone number is inadvertently picked up and it is minimized. It is kept there in case something develops for a period of time, and if it does, then the government must go back to the FISA court and get a court order to essentially target or surveil electronically that person. Let me take a few moments to address the principal concerns that some of my colleagues have expressed about this legislation, which is in effect that this one provision may have on the privacy and civil liberties of United States persons. And let me say that 13 members of the Intelligence Committee who have voted on this do not believe that this is a problem. As I have discussed, Section 702 establishes a framework for the government to acquire foreign intelligence by conducting electronic surveillance on non-United States persons who are believed to be located outside of the United States under a program that is annually approved by the court. The privacy concerns stem from the potential for intelligence collection directed at non-U.S. persons located abroad to result in the incidental collection of communications of U.S. persons. I understand these concerns, and I'd like to explain why I believe that the existing provisions are adequate to address them. First, this section is narrowly tailored to ensure that it may only be used to target United States persons located abroad. It includes specific prohibitions on targeting U.S. persons or persons inside the United States, prohibitions on engaging in so-called reverse targeting, which I believe you, Mr. President, when you were on the committee, had some interest in, which means targeting a non-U.S. person abroad when the real purpose is to obtain their communications with a person inside the United States. That is prohibited. Anytime the intelligence community is seeking to collect the communications of an American, it has to demonstrate that it has probable cause and get an individual FISA court order. Now, this is for collection. Secondly, Congress recognized at the time this Amendments Act was enacted that it's simply not possible to collect intelligence on the communications of a person of interest without also collecting information about the people with whom and about whom that person communicates, including, in some cases, non-targeted United States person. But here's the point. The collection of a non-targeted U.S. person picked up inadvertently can only be surveilled with a FISA court order. The concern was addressed when the FAA was originally drafted. Specifically, in order to protect the privacy and civil liberty of U.S. persons, Congress mandated that for collection conducted under 702, the Attorney General adopt and the FISA court review and approve procedures that minimize the acquisition, retention, and dissemination of non-public information concerning unconsenting U.S. persons. Third, numerous reports and assessments from the U.S. branch that I will describe in a moment provide the committee with extensive visibility into how these minimization procedures work and enable both the Intelligence and the Judiciary Committees to see how these procedures are effective in protecting the privacy and civil liberties of U.S. persons. Oversight by the legislative, judicial, and executive branch of the government over the past 4 years has been extraordinary. We have instituted procedures and requirements that provide protection for the privacy and civil liberties of United States persons. Those entrusted with the responsibility to collect the oversight, the committees of jurisdiction, the FISA court, and the executive branch agencies together remain vigilant and continue to review the operations of these agencies. Let me just give you a quick summary of the 702 reporting requirements. Let me tell you what they include. A semi-annual AG DNI assessment. Every 6 months, the AG and the DNI are required to assess compliance with the targeting and minimization procedures and the acquisition guidelines adopted under 702. They are both further required to submit each assessment to the FISA court and the Congressional Intelligence and Judiciary Committees. The Inspector General of the Department of Justice and the Inspector General of each element of the intelligence community also is authorized to acquire foreign intelligence information under this section. So they review it. The IGs are required to provide copies of such reviews to the Attorney General, to the Director of National Intelligence, and the Congressional Intelligence and Judiciary Committees. So you have the AG reviewing, you have the IG reviewing, then you have reviews by the agency heads. The head of each element of the intelligence community must conduct an acquisition authorized review to determine whether there's reason to believe that foreign intelligence has been or will be obtained from the acquisition. It must include the following: an accounting of the number of disseminated intelligence reports containing a reference to the United States person identity. As a matter of fact, you can go into a classified room and review these reports. Any member has access to that review. Secondly, an accounting of the number of United States person identities subsequently disseminated by that element in response to requests for identities that were not referred to by name or title in the original reporting. You can review that. Third, the number of targets that were later determined to be located in the United States, and to the extent possible, whether communications of such targets were reviewed. You can go in that room and review that. Fourth, a description of any procedures developed by the head of such element of the intelligence community and approved by the Director of National Intelligence to assess the extent to which acquisitions under 702 acquire communications of U.S. persons that may result in such assessment. It goes on and on. Then there's a semi-annual report. Every 6 months, the AG is required to fully inform the Congressional Intelligence and Judiciary Committees concerning the implementation. And there's a whole list of things that must be reviewed and recounted on. Then there's a semi-annual Attorney General review every 6 months. And then there's provision of documents relating to significant construction or interpretation of FISA. I would ask that this list be made part of the record. Thank you very much. So it's not a question of this oversight not being done. I must respectfully disagree with the senator from Oregon. I don't think there's any program that has more rigorous oversight. And we've done hearing after hearing, we've done report after report, and any member of this body that so wishes can go and review this material. Now let me talk about the protection that does exist for privacy, and that's Section 704. Under this section, the intelligence community is required to get a specific judicial order before conducting surveillance on a U.S. person located outside the United States. I mentioned that, and this happens. Before this provision was enacted in 2008, as the product of senators who were concerned, they were listened to, and this was enacted. Before it, the intelligence community could conduct intelligence collection on U.S. persons outside the country with only the approval of the Attorney General, but without a requirement of independent judicial review. And Section 704 provides that judicial review by this special Foreign Intelligence Surveillance Court. This will only be preserved if Section 7 of this Act is reauthorized. If it isn't, the privacy provision goes down with it. Now, let me talk a little bit more about the oversight that we have done, which, if you listen to some, appears to be minor, but it is not. We have held numerous hearings with directors of national intelligence, with Dennis Blair and Jim Clapper, with the head of the NSA, General Alexander, with Bob Mueller at the FBI. We've had Eric Holder appear before the committee to discuss this. And we have heard from intelligence community professionals involved in carrying out surveillance operations, the lawyers who review these operations, and importantly, the inspectors general who carry out oversight of the program and have written reports and letters to the Congress with the results of that report. I'd like to just show that classified letter, if I might. It's classified. I can't read it to you, but I just want to make that members know that if they want to read the IG letter on why what Senator Wyden is asking for cannot be done, please, before you vote, go to our SCIF and read the letter. I don't happen to have it here, but as soon as somebody brings it, I will wave it for a moment so that you see it. The committee's review of these FAA surveillance authorities have included the receipt and examination of dozens of reports concerning the implementation of these authorities over the past 4 years, which the executive branch is required to provide by law. We've received, we've scrutinized all the classified opinions of the court that interpret the law in a significant way. And finally, our staff has held countless briefings with officials from the NSA, the DOJ, the Office of the DNI, and the FISA court itself, including the FBI. Collectively, these assessments, reports, and other information obtained by the committee demonstrate that the government implements the FAA surveillance authorities in a responsible manner with relatively few incidents of non-compliance. Now, let me say this. Where such incidents of non-compliance have arisen, they have been inadvertent. They have not been intentional. They have been the result of human error or technical defect, and they have been promptly reported and remedied. That is important. Through 4 years of oversight, this committee has not identified from all these reports, from all of the meetings, from all of the hearings, we have not identified a single case in which a government official engaged in a willful effort to circumvent or violate the law. Now, keep in mind that the oversight performed by Congress, that's both houses, and the FISA court, comes in addition to the extensive internal oversight of the implementation that's performed by the Department of Justice, the Director of National Intelligence, and multiple IGs. You know, there is a view of some that this country no longer needs to fear attack. I don't share that view. And I've asked the staff to compile arrests that have been made in the last 4 years in America on terrorist plots that have been stopped. And there are 100 arrests that have been made since 2009 and 2012. There have been 16 individuals arrested just this year alone. Let me quickly just review what these plots were. And some of them come right from this program. The counterterrorism and the information came right from this program. And again, if members want to see that, they can go and look in a classified manner. First of all, in November, a month ago, conspiracy to provide material support to terrorists to use a weapon of mass destruction. That's Rais Alam Quasi and Shahryar Alam Quasi. They were arrested by the FBI in Fort Lauderdale, Florida, for conspiring to provide material support to terrorists and to use a weapon of mass destruction. There's another conspiracy to provide material support. Miguel Alejandro Santana Vidriales and David Gojali. And this has to do with an arrest by the FBI who were planning to travel to, well, these people were planning to travel to Afghanistan to attend terrorist training and commit violent jihad. Third, a plot to bomb the New York Federal Reserve Bank. Fourth, a plot to bomb a downtown Chicago bar. Fifth, a conspiracy to provide material support to the Islamic Jihad Union. Sixth, a plot to carry out a suicide bomb attack against the United States Capitol. That was in February of this past year. Seventh, a plot to bomb locations in Tampa, Florida. A plot to bomb New York City targets and troops returning from combat overseas. A plot to assassinate the Saudi ambassador to the United States. And it goes on and on and on. So this has worked. And, you know, as the years go on, the intelligence becomes the way to prevent these attacks. Now that the FBI has geared up a national security unit. They've employed 10,000 people, and information gained through programs like this, through other sources as well, is able to be used to prevent plots from happening. So in 4 years, 100 arrests to prevent something from happening in the United States, some of which comes from this program. So I think it's a vital program. We are doing our level best to keep abreast of it, to see that these reports come in, and I have tried to satisfy Senator Wyden, but apparently have been unable to do so. So I am hopeful that the Senate Intelligence Committee's 13-2 vote to reauthorize part of this important legislation will be voted on. I'd also ask unanimous consent to put into the record the Statement of Administrative Policy on the House bill.
Without objection.
Thank you, Mr. President. It states that the administration strongly supports H.R. 5949, and it goes on to say what the bill would do. It says it is vital, and it produced and continues to produce significant information that is vital to defend the nation against international terrorism and other threats. I am very hopeful that this bill will pass without amendment, and thereupon it can go directly to the President for signature. I'll yield the floor, and I note that Senator Merkley is on the floor, so I will turn it over to him.
Mr. President.
Senator from Oregon.
Mr. President, I call up my amendment, which is at the desk.
The clerk will report.
Senator from Oregon, Mr. Merkley, proposes an amendment number 3435. At the appropriate place, insert the following.
Mr. President, I ask unanimous consent to dispose with further reading of the amendment.
Without objection.
Thank you. I rise this morning to talk about the Foreign Intelligence Surveillance Act and concerns that I have on it and concerns that many of my colleagues have. Earlier this morning, Senator Wyden, my senior senator from Oregon, was discussing at length the importance of the Fourth Amendment, the importance of Americans knowing the boundaries and the rules under which our government collects intelligence, and to know that their rights to privacy are protected. Well, under this Foreign Intelligence Surveillance Act, there are a variety of ways in which that assurance is compromised. And Senator Wyden did a very good job of laying those out. I really want to emphasize that same message, that our country was founded on the principles of privacy and liberty, a protection from an overreaching central government. And during the founding, we set out and said we're going to be a new kind of nation, one that will not permit an overbearing, intrusive government to spy on its citizens or meddle in their private affairs. This belief was enshrined in our Fourth Amendment, and I quote, "The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched, the persons and things to be seized." I think that's an extraordinarily complete description of saying that the government is bound by having to demonstrate before a court probable cause, a case that is put forward and backed up by oath or affirmation, a case that is put forward with great detail about the places to be searched and the persons or things to be seized. So the concept is laid out very clearly about what constitutes unreasonable searches and seizures. It's certainly not that the government can't collect information, just that they have to show probable cause of a crime in order to create that boundary that says the information that we have in our daily lives, and I don't know how much broader you can be than houses, papers, and effects. It pretty much covers the entire parameter. One of the problems, of course, we have is that sometimes lawyers start looking for loopholes. And we can address those loopholes if they're discussed in a public setting, if we can get our hands around them. But if they are loopholes created in secrecy, then indeed it's very hard to have a debate on the floor of the Senate about whether those loopholes or interpretations are right or not, or whether we should change the law in order to address them. Of course, our laws have had to be updated and changed over time to adapt to new technology and changing threats, and one of those developments was the creation of the Foreign Intelligence Surveillance Act in the 1970s. In 1972, the Supreme Court held the Fourth Amendment does not permit warrantless surveillance for intelligence investigations within our country. You may wonder how this even took a Supreme Court decision. The Fourth Amendment is so absolutely clear on this point. So in 1978, Congress enacted FISA, that is, Foreign Intelligence Government Surveillance within our country that is conducted for foreign intelligence purposes. Under FISA, the government had to obtain an order from a special court called the FISA Court in order to spy on Americans. And this is certainly an appropriate boundary to implement. The order required the government to obtain a warrant and show probable cause. These are the same basic common sense protections we've had in place for other types of searches. This development required individualized and particular orders from the FISA court to collect communications. But now let's fast forward to 2001. President Bush decided in secret to authorize the National Security Agency to start a new program of warrantless surveillance inside the United States. This is in complete contravention of the Fourth Amendment, in complete contravention of the law at that time. As I'm sure, and many of my colleagues will certainly recall, this was revealed to the American public 4 years later when it was reported in the New York Times in 2005. And in response, after years of back-and-forth contentious debate, Congress passed the FISA Amendments Act, the bill that we are considering on this floor today. We're considering a reauthorization. This law gave the government new surveillance authorities, but it also included a sunset provision to ensure that Congress examines whether the law is working and the way it was intended. Now, the debate we're having right now on this floor is that reexamination. I'll just note that I think it's unfortunate we're doing this at the last second. We have known that this intelligence law is going to expire for years. It was laid out for a multi-year span. And certainly it is irresponsible for this chamber to be debating this bill under a falsely created pressure that it needs to be done without any amendments in order to match the bill from the House. That is a way of suppressing debate on critical issues here in America. If you care about the Fourth Amendment, if you care about privacy, you should be arguing that we should either create a very short-term extension in order to have this debate fully, or that we should have had this debate months ago so it could be done in a full and responsible manner with no pressure to vote against amendments in order to falsely address the issue of partnering with the House bill. So this law included that sunset provision, and now here we are looking at the extension. It's a single-day debate, crowded here into the holidays when few Americans will be paying attention. But I think it's important, nonetheless, for those of us who are concerned about the boundaries of privacy and feel like the law could be strengthened, to make our case here in hopes that at some point we will be able to have the real type of consideration that these issues merit. In my opinion, there are serious reforms that need to be made before we consider renewing this law. This law is supposed to be about giving our government the tools it needs to collect communications of foreigners outside of our country. If it's possible that our intelligence agencies are using the law to collect and use the communications of Americans without a warrant, that's a problem. Of course, we can't reach conclusions about that in this forum because this is an unclassified discussion. My colleagues, Senator Wyden and Senator Udall, who serve on intelligence, have discussed the loophole in the current law that allows the potential of backdoor searches. This could allow the government to effectively use warrantless searches for the communications of law-abiding Americans. And Senator Wyden has an amendment that relates to closing that loophole. Congress never intended for the intelligence community to have a huge database to sift through without first getting a regular probable cause warrant. But because we don't have the details of exactly how this proceeds and we can't debate this in a public forum, those details, then we are stuck with wrestling with the fact that we need to have the sorts of protections and efforts to close loopholes that Senator Wyden has put forward. What we do know is this past summer, the Director of National Intelligence said, he said this in a public forum, that at least one occasion the FISA court has ruled that the data collection carried out by the government did violate the Fourth Amendment. We also know the FISA court has ruled that the government has circumvented the spirit of the law as well as the letter of the law. But too much else of what we should know about this law remains secret. In fact, we have extremely few details about the courts have interpreted the statute that have been declassified and released to the public. And this goes to the issue of secret law that my colleague from Oregon was discussing earlier. That if you have a phrase in the law and it's been interpreted by a secret court and the interpretation is secret, then you really don't know what the law means. The FISA court is a judicial body established by Congress to consider requests for surveillance made under the FISA Amendments Act. But almost without exception, its decisions, including significant legal interpretations of the statute, remain highly classified. They remain secret. I'm going to put up this chart just to emphasize that this is a big deal. Here in America, if the law makes a reference to what the boundary is, we should understand how the court interprets that boundary so it can be debated. If the court reaches an interpretation that Congress is uncomfortable with, we should be able to change that. But, of course, we can't change it not knowing what the interpretation is because the interpretation is secret. So we are certainly constrained from having the type of debate that our nation was founded on, an open discussion of issues. Now, these are issues that can be addressed without in any way compromising the national security of the United States. Understanding how certain words are interpreted tells us where the line is drawn. But that line, wherever it is drawn, is in fact relevant to whether the intent of Congress is being fulfilled and whether the protection of citizens under the Fourth Amendment is indeed standing strong. An open and democratic society like ours should not be governed by secret laws, and judicial interpretations are as much a part of the law as the words that make up our statutes. The opinions of the FISA court are controlling. They do matter. And when the law is kept secret, public debate, legislative intent, finding the right balance between security and privacy all suffer. In 2010, due to concerns that were raised by a number of senators about the problem of classified FISA court opinions, the Department of Justice and the Office of the Director of National Intelligence said they would establish a process to declassify opinions of the FISA courts that contained important rulings of law. In 2011, prior to her confirmation hearing, Lisa Monaco, who is our Assistant Attorney General for National Security, expressed support for declassifying FISA court opinions that include, quote, significant constructions or interpretations of FISA. So here we have the situation where the Department of Justice and the Office of the Director of National Intelligence said they would establish a process to declassify these opinions. They understood that Americans deserve, and in democracy you deserve to know what the words are being interpreted to mean. And we have the Assistant Attorney General for National Security during her hearings to express that she supports significant constructions or interpretations being made available to the public. But here we are, 2 years later since 2010 expressions, and a year from the confirmation hearing for Lisa, and nothing has been declassified. Nothing. The amendment I'm offering today sets out a three-step process for sending the message that it's important that Americans know the interpretations of these laws. It does so in a fashion that's carefully crafted to make sure that there is no conflict with national security. If the Attorney General decides that a decision, so first step is you call upon the Attorney General to declassify FISA court and court of review opinions that include significant legal interpretations. If the Attorney General makes a decision, however, that it cannot be declassified, those decisions, in a way that does not jeopardize national security, then the amendment requires the administration to declassify summaries of their opinions. So the first point, you have the actual written court opinions. But possibly woven into those court opinions are a variety of contexts about ways and manners of gathering intelligence that pose national security problems. So this amendment says, okay, if that is the case, we certainly don't want to disclose sensitive information about ways and means of collecting intelligence. So declassify summaries. That way we can understand the legal interpretation without adjoining information that might represent a national security problem. And this amendment goes further. If the Attorney General decides that not even a summary can be declassified without compromising national security, then the amendment requires the administration to report to Congress regarding the status of its process for declassifying these opinions, a process the administration has already said it's undertaking. So it just says, tell us where you are. Now, it's probably very clear from my discussion of this that I would prefer the opinions, the actual court opinions, to be declassified, and that perhaps if they're sensitive national security information, it be redacted. That's a normal process in which documents are declassified. You black out or remove the sections that are sensitive. But the amendment I'm presenting goes further in the side of protecting national security, saying you don't have to just do redacted court opinions. You can do a summary that addresses the significant legal interpretations without getting into any of the ways and means that might be embedded in a broader court opinion. And that furthermore, if you make a decision, Mr. Attorney General, that not even that is possible without compromising national security, then update us on the process. But the key point is it requires the Attorney General to make a decision, a clear decision over the national security balance and provide what can be done within the context, within the framework of not compromising our national security. This is so straightforward that anyone bringing the argument to this floor, we shouldn't do this because it compromises national security, really has no case to make. Absolutely no case to make.
The senator's time under the order has expired.
Thank you. I asked the chair, is my understanding that 30 minutes were allocated?
For the general bill.
30 minutes equally divided.
Mr. President,
Thank you.
parliamentary inquiry. Can I yield to Senator Merkley time from general debate in order to let him complete his remarks?
With unanimous consent of the Senate, that can,
I would ask unanimous consent.
without objection. Well, is there objection?
Time to address the bill overall is going to be used on one amendment. I object.
Mr. President, if there is no one else waiting to speak, I ask unanimous consent to speak as in morning business, and will yield when someone is ready and prepared to speak to the bill.
Is there objection?
Thank
Senator from California.
Let me do something I do sometime correct myself. If the senator is offering the time against his amendment, or the time against the bill, using that time, that's fine with me, as long as he's not using the time for the bill.
Mr. President, I think this is acceptable, yes.
I thank the senator.
Thank you, Mr. President, and thank my colleagues for setting out the parameters. I'm going to wrap this up in fairly short order here. Again, I want to emphasize that if any of my colleagues would like to come down and argue that this in any way compromises national security, I'll be happy to have the debate, because this has been laid out very clearly so the Attorney General has complete control over any possible compromise of information related to national security. Indeed, though, I think it's important for this body to continue to express that the spirit of what we do in this nation should be about citizens, to the maximum extent possible, having full and clear understanding of how the letters of the law are being interpreted. Let me show you an example of a passage. Here's a passage about what information can be collected. Reasonable grounds to believe that tangible things sought are relevant to an authorized investigation, other than a threat assessment, conducted in accordance with subsection A2, and so on and so forth. Well, let me just stress these words, relevant to an authorized investigation. Now, there are ongoing investigations, a multitude of investigations about the conduct of individuals and groups around this planet. And one could make the argument that any information in the world helps frame an understanding of what these foreign groups are doing. And so certainly there has been some FISA court decision about what relevant to an authorized investigation means, or what tangible things means. Well, so is this a gateway that is thrown wide open to any level of spying on Americans, or is it not? Is it tightly constrained in understanding with this balance of the Fourth Amendment? We don't know the answer to that. We should be able to know. And if we feel that an administration and the secret court have gone in a direction incompatible with our understanding of what we were seeking to defend, then that would enable us to have that debate here about whether we tighten the language of the law in accordance with such an interpretation. So again, is this an open gateway to any information anywhere in the world, anytime, on anyone, or is it a very, very narrow gate Well, we don't know. We should be able to know as American citizens. We certainly should be able to know as U.S. senators working to protect the Fourth Amendment. Mr. President, we have always struck a balance in this country between an overbearing government and the important pathway to obtaining information relevant to our national security. The amendment that I'm laying forth strikes that balance appropriately. It urges the process to continue of providing an understanding of what the secret court interpretations are. That's very important in democracy. It provides the appropriate balance with national security. It gives clear decision-making authority to the Attorney General in this process. And in that sense, it does the best possible path that honors national security concerns while demanding transparency and accountable for this issue of privacy and protection of the Fourth Amendment. Thank you, Mr. President.
President,
Senator from Oregon.
how much time for purposes of general debate remains on our side and how much under the control of the distinguished chair of the committee?
The opponents have 140 minutes remaining. The proponents have 183 minutes remaining.
Thank you very much, Mr. Chair. Then, to speak again out of our time, to just respond to a couple of points, I also want to commend my colleague, Senator Merkley from Oregon, for an excellent statement. He has been doing yeoman work in terms of trying to promote accountability and transparency on this issue and, frankly, in his work here in the United States Senate. And I'm just going to correct a couple of misconceptions about what's been said, Mr. President, and then also talk on behalf of the good work that Senator Merkley is being done. Now, with respect to this amendment that I will be offering, Mr. President, again, I believe that the Senate cannot say that we passed the smell test with respect to doing vigorous oversight if we don't have some sense of how many Americans, here in our country communicating with each other are being swept up under this legislation. I think we ought to know whether, for purposes of the FISA Amendments Act, generally how many Americans are being swept up under the legislation, and oversight will really be toothless without this kind of information. So I want to correct just one misconception with respect to where we are on the language in the reporting amendment. Now, the distinguished chair of the committee urged senators to come down to the offices of the Senate Select Committee on Intelligence to see the documents that the chair has stated relate to intelligence officials saying that it is impossible for them to estimate the number of law-abiding Americans who have had their communications swept up under the legislation. The fact, however, is when colleagues read the amendment that I will be offering, they will see that I am not requiring anyone to take on a new task of preparing an estimate of how many law-abiding Americans have been swept up in it. This is simply a request to the intelligence community saying that if any estimate has already been done, Mr. President, that estimate ought to be provided. So when the distinguished chair of the committee says that senators should go over to the committee's offices and look at the documents that state the intelligence community cannot do a new estimate, I just want senators to know that the language of my amendment does not ask for a new estimate. In no way does it ask for a new estimate. It simply says if an estimate has been done, that estimate ought to be furnished. And if no estimate has been done, the answer to that is simply no. We'll be very clear about it, and the matter will have been clarified. And if no estimate has been done, then fine, the answer would be no. And then, as I indicated earlier, Mr. President, the amendment also requires the intelligence community to state whether any wholly domestic communications have been collected. That is an answer, again, yes or no. And then, finally, it requires a response to whether or not the National Security Agency has collected personal information on millions of Americans, and that, too, is a very straightforward answer. So I think when we talk about this kind of, information, we ought to come back to the fact that no sources and methods in the intelligence community would be compromised. In no way would the operations, the important work of the intelligence community, be interrupted. What it would simply do is provide us what I think are really the basics that this Senate needs to be able to say it is doing real oversight over a very broad area of surveillance law. And I hope that senators will ask themselves as we look at this, do we know here in the Senate whether anyone has ever estimated how many U.S. phone calls and emails have been warrantlessly collected under the statute? Does the senator know whether any wholly domestic phone calls and emails have been collected under this statute? Does the senator know whether the government has ever conducted any warrantless backdoor searches for Americans' communications? If not, this is the Senate's chance to answer that question. And when our constituents come forward and ask us whether the government is protecting our privacy rights as we protect our security, the question really is, how does the senator look their constituents in the eye and tell them they don't know and really aren't in a position to get what strikes me as information, Mr. President, that is essential to pass the smell test when it comes to this body doing basic oversight over what is certainly a broad and, for many Americans, rather controversial surveillance law. Now, I assume, because we've already heard some characterizations of my amendment which are simply factually incorrect, that we'll have other responses to the reporting amendment in terms of objections. Now, I've already, stated my first, concern, the intelligence community stating that they can't estimate how many Americans' communications are collected under the key section 702 of FISA. And my response, again, is that when senators look at the text of the amendment, it doesn't require anybody to do an estimate. It simply says that if estimates do exist, they ought to be provided to the Congress. And I do not think that when it comes to our oversight responsibilities, that is a request that is excessive or unreasonable. Second, I think we will hear that the House and Senate Intelligence Committees already do oversight of FISA. Well, every member of the Congress has to vote on whether or not to renew the FISA Amendments Act. So, frankly, I think every member of this body ought to be able to get a basic understanding of how the law actually works, and that is not available today. Next, we will hear that the intelligence community has already provided the Congress with lots of information about the FISA Amendments Act. As the presiding officer knows from his service on the committee, much of that information is in highly classified documents that are difficult for most members to review. And the reality is that most members literally have no staff who have the requisite security clearance in order to be able to read them. This amendment that I am talking about with respect to basic information on the number of Americans who have their communications swept up under FISA, whether Americans with respect to wholly domestic communications have been swept up under this law. This is information, in my view, that ought to be available to this body, and it ought to be available in documents that members can actually access, and frankly ought to be available in a single document that members can access. Now, we will also hear in connection with the discussion about these issues is that the answers to these questions, Mr. President, should not be made public. The amendment that I am going to be offering with respect to getting a rough set of estimates with respect to how many Americans are being swept up under these authorities and whether an estimate actually even exists. The amendment I'm offering gives the President full authority to redact whatever information he wishes from the public version of the report. Under the amendment that I am pursuing, the executive branch would have full discretion to decide whether it's appropriate to make any of this information public or not. So, as we ensure more transparency and more accountability with respect to this information and access to it, no sources and methods that have to be protected, the important work that the Intelligence Committee is doing, none of this is compromised in any way, because the last word with respect to information that the Senate and the public receives, the last word on this subject is the call of the President of the United States, who has the full discretion to decide whether it's appropriate to make any of this information public or not. Now, finally, we're undoubtedly going to hear that the law is about to expire and amendments will slow it down. Mr. President, first of all, I think that many of us would have rather had this debate, earlier in this session of the Senate, and had there been more dialogue on a lot of these issues, that would have been possible. But we are where we are. I think we understand that. We understand that the huge challenge of the fiscal cliff is vital in terms of our work this week. But I continue to believe that the other body is perfectly capable of passing this legislation again before the end of the year. The amendments that are being offered all go to the issue of transparency. They go to the issue of accountability, and none of them, not a one of them, would jeopardize the important daily work, what are called the issues relating to sources and methods and the work of the intelligence community. Not a one of these amendments would jeopardize those ongoing kind of operations. The Congress can make amendments to improve oversight and still keep this law from expiring. So with respect to the reporting amendment, again, Mr. President, I hope that on the argument made by the distinguished chair of the committee that the intelligence community has said that they can't estimate how many Americans' communications have been collected under Section 702, and she has urged that senators go to the office of the Intelligence Committee. I just hope that colleagues, when they look at the text of the amendment does something different than the issue that has been raised by the distinguished chair of the committee. The amendment does not require anyone to do an estimate. It simply says that if an estimate already exists, that estimate ought to be provided to the Congress. Now, Mr. President, let me also make some brief remarks on this issue of secret law that touches on the point raised by my colleague from Oregon, Senator Merkley, who I think has given a good presentation here on the floor and has a very good amendment. When the laws are interpreted in secret, the results frequently fail to stand up to public scrutiny. And we've talked about this on the floor and in the committee, and it really isn't that surprising when you think about it. The lawmaking process in our country is often cumbersome, it's often frustrating, and it's often contentious. But over the long run, I think we know that this process is really the envy of the world because it gives us a chance to have a real debate, generate support of most Americans, because then people see when they've had a chance to be part of a discussion that they are really empowered in our system of government. On the other hand, when laws are secretly interpreted behind closed doors by a small number of government officials without public scrutiny or debate, you're much more likely to end up with interpretations of the law that go well beyond the boundaries of what the public accepts or supports. So let's be clear that when we're talking about a public, scrutiny and having, debates, that's what allows the American people to see that those of us who are honored to serve them are following, their will. But sometimes it is entirely legitimate for government agencies to keep certain information secret. In a democratic society, of course, citizens rightly expect that their government will not arbitrarily keep information from them. And throughout our history, our people have guarded their right to know. But I think we also know that our constituents acknowledge that certain limited exceptions exist to this principle of openness. For example, most Americans acknowledge that tax collectors need to have access to some, financial, information, but that the government does not have the right to share this information openly. So we strike the appropriate balance on a whole host of these issues on a regular basis. Another limited exception exists for the protection of national security. The U.S. government has an inherent responsibility to protect its citizens from threats, and it can do this most effectively if it's sometimes allowed to operate in secrecy. I don't expect our generals to publicly discuss the details of every troop movement in Afghanistan any more than Americans expected George Washington to publish his strategy for the Battle of Yorktown. By the same token, American citizens recognize that their government may sometimes rely on secret intelligence collection methods in order to ensure national security, ensure public safety, and they recognize that these methods often are more effective when the details, what are really the operations and methods, as we characterize them under intelligence principles, remain secret. But while Americans recognize that government agencies will sometimes rely on secret sources and methods to collect intelligence information, Americans expect that these agencies will at all times operate within the boundaries of publicly understood law. Now, I have had the honor, Mr. President, to serve on the intelligence community now for over a decade. I don't take a back seat to anyone when it comes to the importance of protecting genuine, sensitive details about the work being done in the intelligence community, and particularly their sources and methods. But, Mr. President, the law itself should never be secret. The law itself should never be secret because voters have a right to know what the law says and what their government thinks the text of the law means, so they can make a judgment about whether the law has been appropriately written, and they can then ratify or reject the decisions that elected officials make on their behalf. Now, when it comes to most government functions, the public can directly observe the functions of government, and the typical citizen can decide for themselves whether they support or agree with the things that their government is doing. American citizens can visit our national forests. We take particular pride in them in our part of the country, and decide for themselves whether the forests are being appropriately managed. When our citizens drive on the interstate, they can decide for themselves whether those highways have been properly laid out and adequately maintained. If they see that an individual is being punished, they can make judgments for themselves whether that sentence was too harsh or too lenient. But they generally can't decide for themselves whether intelligence agencies are operating within the law. That's why, as the U.S. intelligence community evolved over the past several decades, the Congress has set up a number of watchdog and oversight mechanisms to ensure that intelligence agencies follow the law rather than violate it. That is why both the House and the Senate have select intelligence committees. It's also why the Congress created the Foreign Intelligence Surveillance Court. And it's why the Congress created a number of statutory inspectors general to act as independent watchdogs inside the intelligence agencies themselves. All of these oversight entities, one of which, Mr. President, I'm proud to serve on, the Senate Select Committee on Intelligence, all of them were created, at least in part, to ensure that intelligence agencies carry out all of their activities within the boundaries of publicly understood law. But I come back to my reason for bringing this issue up this afternoon, Mr. President. The law itself always ought to be public, and government officials must not be allowed to fall into the trap of secretly reinterpreting the law in a way that creates a gap between what the public thinks the law says and what the government is secretly claiming that the law says. Anytime that's being done, first, it violates the public trust. Second, I have long felt that allowing this kind of gap, a gap between the government's secret interpretation of the law and what the public thinks the law is, undermines the confidence that our people are going to have in government, and, by the way, is pretty short-sighted, because history shows that the secret interpretations of the law aren't likely to stay secret forever. And when the public eventually finds out that government agencies are rewriting these surveillance laws in secret, the result is invariably a backlash and an erosion of confidence in these important government intelligence agencies and the important work that I've noted this morning our intelligence officials are doing. So this is a big problem, Mr. President. Our intelligence and national security agencies are staffed by exceptionally hardworking and talented men and women, and the work that they do is extraordinarily important. If the public loses confidence in these agencies, it doesn't just undercut morale, it makes it harder for these agencies to do their jobs. If you ask the head of any intelligence agency, particularly an agency that's involved in domestic surveillance in any way, he or she will tell you that public trust is a vital commodity and voluntary cooperation from law-abiding Americans is critical to the effectiveness of their agencies. If members of the public lose confidence in these government agencies because they think government officials are rewriting surveillance laws in secret, those agencies are going to be less effective. And, Mr. President, I don't want to see that happen. On my watch, I don't want to be part of anything that makes our intelligence agencies less effective. These officials at these government agencies do not, get up in the morning to do their work with malicious intent. They work very hard to protect intelligence sources and methods for good reasons, and sometimes what happens is people lose sight of the difference between protecting sources and methods, which ought to be kept secret, and the law itself, which should not be kept secret. Sometimes they even go so far as to argue that keeping the interpretation of the law secret is actually necessary because it prevents our nation's adversaries from figuring out what our intelligence agencies are allowed to do. My own view is this is really Alice in Wonderland, logic, but if the U.S. government were to actually adopt it, then all of our surveillance laws would be kept secret because that would, I guess you could argue, be even more useful. When Congress passed the Foreign Intelligence Surveillance Act in 1978, it would have been useful to keep the law secret from the KGB so that Soviet agents wouldn't know whether the FBI was allowed to track them down. But American laws and the American Constitution shouldn't be public only when government officials think it's convenient. They ought to be public all the time. Americans ought to be able to find out what their government thinks those laws mean, and I think it is possible to do that while still ensuring that sensitive information, the information about sources and methods and the operations in the intelligence community are appropriately kept secret. My own view is the executive branch of the United States has so far failed to live up to their promises of greater transparency in this area, greater commitment to ensuring that the public sees how our laws are being interpreted. And as long as there is a gap, Mr. President, between the way the government interprets these laws and what the public law says when you're sitting at home and looking it up, on your laptop, I am going to do everything I can to reduce that gap and to ensure that our citizens, consistent with our national security, have additional information with respect to how our laws are interpreted. We can do that while at the same time protecting the critical work that's being done by officials in the intelligence community. And with that, Mr. President, I'd be happy to yield to the distinguished chair of the committee.